Welcome back. Now, in this section of the course, we're talking about employment law serving as the tool to promote a socially valued activity. And we talked about religion, and now we're going to talk about disability. And the socially valued activity here is the hiring of disabled individuals. Disability discrimination is often a hidden form of discrimination in that employers make employment decisions, and given the option of choosing a disabled individual as opposed to an abled individual, they will discriminate against the disabled individual. It's going to be more difficult. It's going to impose a cost on the employer to hire the disabled individual. And prior to legislation, the fact is employers consistently refused to hire individuals with disabilities without the requirement to hire them. In fact, they didn't hire them, and they did so on the basis of, hey, there's a cost involved. If I can hire someone to do the job without the need to accommodate their disability, I'd prefer to do that. So accommodating disabilities costs money. Just as with religious accommodation, though, when we adopted a prohibition on on disability discrimination in the Americans with Disabilities Act, we took into account that sometimes employers are going to have to endure cost that they would otherwise not have to endure. Because without regulation, employers were not willing to bear the burden. They were not willing to spend the money to accommodate disabilities. So in this lecture, we're going to look at the Americans with Disabilities Act and its regulation of disability discrimination. Now, the regulation of disability discrimination actually has a long history. Congress first addressed this matter in 1973 with the Vocational Rehabilitation Act. Now, this Vocational Rehabilitation Act applied only to federal contractors. And the reason that it was necessary in 1973 was this was following the war in Vietnam, and we had a number of wounded veterans returning and attempting to enter into the workforce and being denied the opportunity to get jobs because of their disabilities. So Congress passed an act that said if you do business with the federal government, you cannot discriminate on the basis of disabilities. And instead, you had to take affirmative action to employ and promote qualified disabled individuals. Now, the Americans with Disabilities Act became effective in 1992. And in many ways, the impact of the ADA has been less than what its advocates hoped for. That it has not had the impact that it was supposed to. But in 2008, Congress attempted to strengthen the ADA, and they did so with a separate act called the Americans with Disabilities Act Amendment Act, the ADAA. And what that did was it attempted to strengthen the goals, the objectives of the ADA. And so what they did was to clarify and to broaden the definition of disability and to increase the coverage of the ADA. The major hurdle that disabled individuals had to overcome in early ADA analysis, and I say early, for the first 10, 15 years of its existence, was establishing disability, was to establish, are you disabled? And we'll talk about the test for disability. But what the ADAA said was essentially, we're going to make more people disabled. We're going to broaden the class of people who are disabled. So the ADA protects disabled from three types of barriers. And the first is intentional discrimination for reasons of social bias. That you are object to disabled individuals, you don't want to have to see them in your daily work, and so therefore you don't hire them for your open position. It's also meant to affect neutral standards with disparate impact on the disabled. We have a neutral standard but has this disparate impact on disabled individuals. And the third is discrimination as a result of barriers to job performance. And when we talk about barriers, we're primarily talking about physical barriers, meaning if there are steps to get into to the company, to the employer, and you want to apply for a job, but you're in a wheelchair and you can't navigate the steps, then that's a barrier to your job performance. You cannot get in the door, literally cannot get in the door. Now, it's in this third area that, in fact, the ADA has probably had its greatest effect, that we have seen a result of physical barriers to job performance. While still difficult, we've at least seen a lessening of those. One of the early advocates for the ADA was actually a Oklahoma State student who was injured in an automobile accident while driving up and down the strip back in the 70s, and was injured and lost the ability to walk. Now, after he left the hospital and came back to OSU, he discovered that it was virtually impossible for him to go to classes because of the building design. And so he actually transferred to Oral Roberts University in Tulsa, which was a much newer campus and had much fewer inhibitions, barriers to getting around campus. So it's in this third area that we've probably seen the greatest effect of the ADA, of allowing people to enter into the world. How do we prove a case for disability discrimination? Again, we start with a prima facie case. Now, there are 4 elements to the prima facie case. You must establish that you are disabled, he or she is disabled, that he or she is otherwise qualified for the position, that the disability can be reasonably accommodated, and there was an adverse employment decision. So these are the 4 elements of the prima facie case, and that means in order to establish the prima facie case and shift the burden to the defendant, the employee plaintiff must establish each of these. And each of these has a distinct meaning that is different from the other types of religious discrimination. We'll go through each step one by one. And the first is he or she is disabled. How do we know what disability is? Well, the ADA has a definition of disability. It's a physical or mental impairment that substantially limits one or more major life activities of an individual. So therefore, we can see the elements of establishing a disability. Things like physical or mental impairment, substantially limits, and major life activities. And prior to the ADAA and its enactment in 2008, it didn't go into effect until 2010, 2011. Prior to that, we saw much litigation revolving around that definition of disability. Does someone meet the standard of disability? Moreover, you're disabled if you've had this in the past but do not have it now, or if others regard you as having that type of impairment. So the definition of disability, therefore, has these 3 elements: impairment, major life activity, and substantial limitation. An impairment that substantially limits one major life activity. And historically, there was a lot of analysis that went through each of these. Now, fortunately, you're taking this class now and not 6-7 years ago, because now, although these elements are still there, and that's still the law, we have seen on the part of courts a willingness to expand their notion of disability. We know that impairment must substantially limit one or more major life activities. And there are a number of court decisions in which they attempt to define major life activity and what is a substantial limitation of that major life activity. The positive effects of mitigating measures should not be considered in determining substantial limitation. If you have Parkinson's disease, for instance, which causes you to shake, and you can take pills to minimize the shaking, just because you can do that, that should not be considered in determining whether there's a substantial limitation. You have to look at the non-mitigated disability.